We are here on the plaintiff father's motion for a temporary order. Mr. Spanaki.
Thank you, Your Honor. There might have been a motion today where kids are in crisis. That's not this case. You might have had a motion this morning about parents causing problems for their kids. That's not this case. You might have even had a case with a mother who's trying to steal someone's baby from the mother and deny her all her rights as a mother. That is not this case. We have both filed documents to show you these are wonderful, thriving children, very loving and involved and well situated in their schools and community and their activities. And they're just great kids. And I used to have a t-shirt, great parents or make great kids. So I think there's something to do with that these parents have done a good job with these two kids, a 10th grader and a 7th grader, both girls. Father, both these people, I'm sure, suffered in their own ways some unhappiness for years. In March, at a counseling session, father said, I can't do this anymore, and we're going to have to process a divorce. Mom doesn't want the divorce. In May, he found a home less than 6 miles away. The school is in between the two houses. It's brand new construction. The kids have their own rooms. There's a fully stocked bathroom, a fully stocked fridge. There's desks and chairs and thermoses and lunch boxes and everything else. So we have a good situation set up. Mr. Vanderwerf has tried to get some kind of parenting plan set up. In May, mom said, well, let's wait till the summer. In the summer, there was just a series of excuses, delays, cancellations. Mr. Vanderwerf was saying, can we talk about this? And Mrs. Vanderwerf, I'll read you a couple of the texts, but she wasn't cooperative. He asked, well, maybe we should meet with a mediator. She wasn't cooperative. She said, having them stay with you isn't something I've agreed to yet. That was in June. Then there's just these things. Well, that won't work. Tomorrow would be better. Sorry, we're out. We ended up out. I'm in the middle of something. Tonight won't work. I'm okay with the girl spending the day with you. I'm okay with you having dinner with this one daughter. You can come to the house on Tuesdays and Thursdays at 7:30 p.m. and spend time with your daughters. So that's kind of how this went. We drafted a full proposal. Part of that was because the largest single asset is the home, the marital home with 450,000 or so equity. We'll find out. And we understood that Mrs. Vanderwerf wanted the home. The only way she can realistically keep it is to do a buyout. And but we'll figure that stuff out. So the main thing for the parenting is at this point, Mrs. Vanderwerf says, well, let's wait till the end of November. You know, we have to start something. If mother had said, let's start the phase in with what she calls phase 2, which is every Wednesday overnight and the weekends from Friday to Monday. And if she had said, we'll do the 2255, but not till January 2026, we wouldn't even be here. But they couldn't do that, so we need to get this going. We provided as our Exhibit 1 a fully laid out 2255 parenting plan with holidays and everything else situated. We have Exhibit 2 is the Michigan Child Support Formula calculation. The claim was father hasn't provided any money to mother. At the beginning of this year, there was more than $46,000 in a money market. Now there's 10,000. Where did the money go? Father used 5,000 for a down payment. Mother took 30,000 out. She tells the court that her income's just over 30,000. It's actually 34. We know that because now she says she gets 2,000 for coaching. And she told the insurance company when she signed up for benefits through the school that she was making 32,000, over $32,000. But we calculated her at 32. We didn't calculate the 2,000. And that ends up being $812 a month. Her shortfall on her budget, which doesn't include a mortgage or a car payment, she gets health insurance through work, includes some fluff, but just looking at her budget, she says she has a shortfall of $380. Well, she's making over 3,000 more than she puts on her budget. But we'll figure the spousal support part out later. And I think either the house is going to end up being sold or we'll do a buyout of spousal support. But for now, hitting the $812, starting up the 2255 gets her budget covered because 812 minus 380. I mean, she's got money left over. We also had plaintiff's exhibit 3, which is the mutual restraining order. I understand that from counsel's submission that that's fine. So that's what we're asking for, is to go with the full plan that we laid out, the child support that corresponds with that, and the mutual restraining order.
Thank you. Ms. Rademacher.
Thank you, Your Honor. Your Honor, we aren't dealing with a 6 and 8-year-old, which pretty much just go where they're told. We're dealing with a 12 and 16-year-old that have lived in this marital home their entire lives, mostly with mom, because mom was a stay-at-home mom for about 14 years. Dad travels, so he's in and out of that residence and was about a week a month. And he works West Coast time, so even when the kids have spent time with him, his schedule is such that it's 3 hours. So they're home in the evening with him, but he's still needing to work. So the children have the main custodial environment, and the status quo is, and their ages dictate that they don't want to play house somewhere else. Just because dad wanted to move doesn't mean that they want to move as well. Now, that doesn't mean that they don't want a relationship with their dad. The parties have cooperated and orchestrated continuing contact with the children. A lot of Mr. Vanderwerf's contact with the children was directly arranged between him and the children. So that's the schedule that he developed with them. In addition, like this August, September, he spent a lot more time with the girlfriend that now we've discovered he has. And he even no-showed for their daughter's dual cross country with no text, nothing. So his mindset's a little skewed right now. We do have to get this case on schedule, but not because he wants to play house somewhere else. We need to honor the custodial environment that these children have. And that is why I have that phase 1, phase 2 schedule where it's a pattern that we're establishing. Kids, Wednesdays are dads. Weekends, every other weekends are dads. We'll start keeping you at home on the evenings, but start getting used to the environment at dad's and being prepared for school in the morning and so forth. And that's why in phase 2, we can go in quickly within a 30-day cycle into a Sunday overnight and then the Wednesday overnights. This is very much taking into consideration the reasonable preference of the children. It was stated that the children wanted 225. That is absolutely not what has been happening, nor is what we're hearing. I think these kids are being put in the middle, feeling perhaps guilty. I don't know. But the bottom line is, if we look at the pattern since May, these children continue to stay and have their routine, a 12 and 16-year-old in the marital home. And that's what is comfortable for them. And we can start with this transition, phase 1, phase 2, as I've indicated in my motion. The text that I heard, I asked my client, I believe they're taken out of context. And it is truly just working towards something. You know, these parties have never been divorced before. They don't know. As far as the financial situation, my client handled all the household bills. in the house, and she transferred because Mr. Vanderwerf no longer deposits his check into the party's account from which he supported the family. And so he left the money market account for her to use, and she would transfer it to pay the bills. That's what she's done, and that's why it's dissipated. So we need to stop that bleeding. And that's why once we establish the child support, that will help. And the spousal support, I'm looking at a difference of him making 140,000 a year and her about 32. There's certainly a disparity. I don't think she has to live dollar to dollar. That's not fair either on this 28-year marriage. So if we look at the schedule that I've proposed, and I attached my child support guidelines as well, that leaves a child support amount in a significant amount that I believe also does meet the budget for now. And we can reserve spousal support while we work out the rest of the details, as Mr. Zarnecki said. We don't include, keep in mind that their oldest son, Sam, who's 19, he goes to college in Albion. Mom has helped him in the past with tuition and things of that nature. He comes home from school, and the parties are going to just have to continue to agree on those additional expenses, which are not in this budget. So, Your Honor, this isn't a tug of war, and that was kind of my point of my little epitaph in the beginning of my motion, is that we are dealing with real children, girls who are young adults that have their stuff, that have routine, that love their family, and want to do this in a methodical way, that they do not want to have complete disruption of their lives, living in two different, one on one side, 1 foot on the other. That is not fair to them. And that's why we asked the schedule that we did. I'd ask the court to adopt my child support number, because that would balance the budget, as well as take into consideration the flexibility that I think will occur. And the mutual restraining order, I don't object, of course. To the assets, I think Mr. Zarnecki put in there something about the harassing and that type of thing. I don't think we need a behavioral restraining order, but I'll leave that to the court's discretion, but no objection to a mutual restraining order regarding assets. Thank you.
Mr.
Yeah, I would
Sarnecki.
just like to add one comment, and I heard this is the only house the kids have ever known. They don't want to play house anywhere else. Mr. Vanderwerf wants them to play house somewhere else. There's a difference between a house and a home. These children will have two homes wherever the parents live. So let's just get off of that idea that this brick and mortar makes the difference and made these children great. It was these parents working together. Thank you.
All right, thank you. I heard an agreement regarding a mutual restraining order regarding assets. So that certainly can be implemented as an order. And Mr. Sarnecki, you didn't really respond to the behavioral part of a mutual restraining order.
Well, I don't know what the harm is in telling people not to harass each other, but you can decide that, Your Honor.
Okay, all right. Let's leave it out for now. I hope it won't be necessary.
Okay.
Because I'm not hearing a strong argument in favor. So, all right. As far as the parenting time, I understand this is difficult. It's difficult for the parents. It's difficult for the kids, especially difficult for teenage girls. Teenage boys probably would have similar issues. It's really crappy to have your parents get a divorce at any age, but certainly at this age. So I get that. But to counterbalance that, this family, it's been 6 months. And this family needs to start moving on and accepting kind of the reality of what's happening, and that there's a new reality, which involves two parents in two separate homes. So, but again, trying to take into consideration these children's natural feelings and reluctance for things to change. But the court finds that implementing phase 2 right now is appropriate in this case. Phase 2 was proposed by Ms. Rademacher as opposed to having a phase 1 then a phase 2. Just because at some point this Band-Aid needs to be ripped off, and I realize phase 1 was proposed to be a fairly short period of time, but I think given the amount of time that's gone by, let's just start with phase 2. The court will grant the mother exclusive use of the marital home. And I'm sorry, Mr. Sarnacki, what was your position regarding the spousal support?
Well, what I heard Ms. Rademacher say is that they want to reserve it, and I'm fine with that.
Okay, what about the child support?
Well, I think the child support that they're asking for is excessive because their budget underreported income that they've already admitted to the benefits department and probably included all kinds of other things. But if we picked a number in between, we can deal with that on the back end of the case. I don't remember what counsel's.
Guys, today we're stepping into a custody battle where both parents swear they're doing everything right. But the judge is about to decide who's telling the truth and who's just talking.
Can I ask what under reporting of income are you referring to?
She said she makes 30,000, but when she applied for the benefits with the National Services Insurance or whatever, she wrote down over $32,000. Then she also that was for her salary. Then she also has now apparently 2,000 for cross country, so she's up to 34,000.
Okay, so I can tell you that the hourly rate she makes, and she doesn't get paid year round either, is exactly the amount on my child support guidelines of her salary. And then you would add $2,000 to that. So 32,843 is what her, I use 2,000 for her coaching, and then how much per hour? I've got it right here. She makes $20.84 an hour. And then she only works, she doesn't get paid all year round. So if you average that all out, that's where you get that 30,800.
Under penalty of perjury, she told the National Insurance Services that as an administrative assistant, she makes $32,177 working 40 hours a week.
Well, let me just interject a minute here.
It's not that far apart.
No, that was going to be the point that I make, and it's got to be a pretty significant bump in income for it to make a huge difference in the child support formula, as we know.
Right.
But this is only a temporary order, so I think $1,600 a month in child support and reserve on the spousal support is appropriate. And then that can be, retroactively modified depending on the proofs or the party's settlement.
So we have legal custody, physical custody, and the 2255 question.
Well, at this point, joint legal and joint physical is appropriate. And then the 2255 question, I think, is something that the court can look at going forward. We will implement the phase 2 and see how that goes. And then with the idea that maybe phase 3 would be something like a 2255 if everything goes well.
Okay, thank you, Your Honor.
Anything else?
I'll prepare the order. Thank you.
All right. We're here on a motion to enter the judgment of divorce and uniform child support order that was filed by the plaintiff, Ms. Wilsner.
Yes, Your Honor. The judgment of divorce was drafted after the mediation was held in this matter back in May. Took quite some time for us to get things in order, but they were in order. And then by the time that they were ready to be signed, this motion by defendant had popped up. So I think there's a little bit of hesitancy hesitance to enter it, even though it comports with the friend of the court order that was entered in this case and the mediation agreement. So simply asking the court to finally allow these parties to get divorced, and to enter that today.
Mr. Browning?
Thank you. I sent a couple times the judgment of divorce draft that I received from Ms. Wilsner to Mr. Norris, and I think that at this point, the only hesitancy, he's not saying that he didn't agree to these things back at mediation, but we do have the underlying hearing that is of concern to us today.
All right, well, it's a separate issue. Agreement at mediation is an agreement. It's a contract the court has to enforce. So the court will grant the motion to enter the judgment pursuant to the mediation order, and we'll sign that. And now we'll move on to Mr. Norris's motion regarding parenting time. Mr. Browning.
Thank you, Your Honor. In regards to this mediation agreement that was signed, I guess you probably reviewed our brief, but it's been a while. So the heart of it is that Miss Norris actively concealed the criminal record of the person that she had moved into, not simply failing to mention it, but giving Mr. Norris an incorrect name so that he wouldn't find it. Now, he wasn't able to find anybody, I guess, under the name that he was given, so he kept digging. Then he learned that the person that is now living with his kids has a pretty alarming criminal history involving assault with intent to do great bodily harm, for which he served several years in prison, I think 4+, and this was against a domestic partner. And apparently he was charged with 2 counts, which we wouldn't know, except that he actually appealed this to the Court of Appeals, that his Cobbs wasn't correct. And basically, according to the guilty plea, he choked his girlfriend, I believe, until, or, something like until she passed out, then came back, hence 2 charges, came back and did it again, I mean. And so this is Mr. Norris's problem with the current custody arrangement, is now his kids live with someone like this 8 overnights out of 14, and he didn't get any chance to vet that or even meet the guy or anything of the sort before signing this agreement at mediation. And it isn't so much that this was unknown to Miss Norris. She gave him a false name for a reason. That reason being so that hopefully he wouldn't ever learn about this. And so he's stuck with a custody agreement that he agreed to, which he would never have signed otherwise. And in late September, Ms. Norris continued to express her concern with her living situation and went to Matthew, her ex, well, not fully her ex, but that's a procedural thing we just addressed right now, today, about wanting to move out and expressing that this man, Graham, shouldn't be around, shouldn't live in a house with children, and that she saw a side of him that she didn't like. So it's not like that they've lived together and it's been fine, it's been great. Even Danielle is concerned about this living situation. So again, she gave a different name, and she gave that same name at mediation when asked to say who her partner was. She's given alternate names of Graham Young, Graham Parker, and his iChat was found under Graham Dickinson Parker, and this was verified using information regarding the license plate. And Danielle isn't disputing that we've now found this person, and Mr. Norris did, and his past. And it isn't a one-off that happened years ago. He's continuing to have police contact. He got a disturbing the peace charge recently, and while that is nothing on that level, it indicates that there is still this concerning behavior. And that is essentially why we have filed this motion for a change in parenting time.
Thank you. Ms. Wilson.
Your Honor, thank you. This motion is actually couched as a motion to change parenting time, but it really is a motion for a change in custody if you look at the request. And I don't believe that they've met the preponderance of the evidence here for Varvarka. There are some inaccuracies in what Attorney Browning has stated. Mr. Norris did meet Graham prior to Danielle and the kids moving in with him. They've met numerous times. They've interacted numerous times. Yes, we aren't in dispute. We aren't disputing the facts of his criminal history, but I think they are, by saying recently he's been in trouble, that was actually before he and Danielle were together. That was, I think, earlier in the year, and they were together. I think they've been together since July. And yes, Danielle and the kids do live with him in his house. That he purchased recently. He has his own business, Graham does. I'm not trying to I don't want to be disingenuous about his criminal history, but the allegations that Danielle has sought some sort of camaraderie with Mr. Norris about how she's not, or she is concerned about the kids in that house is simply untrue. As recently as, my last meeting with her, she has no concerns about Mr. Parker, about his interactions with the kids, his interactions with her. There have been no police involvement regarding anything here. There's been no CPS reports, no investigation. And in fact, the kids are happy and healthy, and they're settled in this new home that they've been in since, I believe, August. And in fact, Mr. Norris is relying on Miss Norris to use some of his parenting time for her to keep the kids while he's either at work or while he's in paramedic school. So he's actually giving her more parenting time on the basis of their mediation agreement being a first right of refusal, where she essentially has the kids more than 8 out of 14 days. I would say it's unequal. She has the kids most of the time during the week. And Mr. Norris lives in Spring Lake, which would not be an easy transition for the kids. He could not get them to school on time with his schedules. I'm not sure how this parenting time plan or idea he has will work logistically when he's relying on Miss Norris both for his parenting time and using the babysitter that they have that she has now to help him with his parenting time. Ultimately, though, I think there has not been a showing of a material change that affects the children's well-being at all, and I think this motion should be denied.
All right, thank you. The standard is proper cause or change in circumstance. The I guess admissions today convinced the court that there was an omission, at least, at the very least, regarding this person's history. And certainly, in the best interest of the children, I think this needs to be investigated. So the court will refer this to the front of the court for an investigation regarding custody, even though it was couched as parenting time. I agree with Ms. Wilsner that this really is, at least the relief requested is more of a change in custody. And that Mr. Norris is to pay the fee for the front of the court investigation. All right, we're adjourned. Thank you.
Thank you so much, Your Honor.
We are here on the plaintiff's objection to the referee order granting the defendant's motion for summary judgment. I do see that a transcript of that referee hearing was provided to the court. And I will ask Ms. Sierra, I have read it, but go ahead and say what
Yes,
you'd like at this point.
Thank you, Your Honor. Candidly, the objection speaks for itself. I think that this ruling was premature, and as the case Mac v. Schmaus indicates, that my clients are entitled to a hearing. And I did see that there was the hearing with the referee, but that was a 9-minute hearing. There was not an opportunity for them to give testimony or anything along those lines. I think that the reality of the situation is this is a very unfortunate situation. We have a tragedy, and then we just have a whole list of things that have happened where we have kids that are really not they're not in a situation that gives them the ability to receive love from everybody in their life, and that's not best for them, and that is not aligned with what's in their best interest. Moreover, I think that it's important to know that when this tragedy happened, the Cunliffes, they stepped in and they were very hands-on with these children, and then to have that just taken away, that is concerning. And I do think that this warrants at least a hearing, and a hearing where they can give testimony and the court can actually hear what has happened here so we can move forward. The goal here should be to get some grandparenting time established, not just for my clients, but really for these children. As the objection points out, this case that came down, and it was right around the time of the hearing. So I would not expect that to be. I could see how that happened, but the reality is, Your Honor, that my clients are entitled to a hearing at the very least on this issue.
Thank you, Mr. Masad.
Because I think it's important to point out that what they're trying to do is confuse the issue. This is a de novo on a C10 motion. Now, to get past that, the moving party has to demonstrate that there's a genuine issue of material fact. Love for a grandchild, clearly, although obvious, does not recommend or to reach the threshold burden here. I mean, I hope that they love their grandchildren, but there's been no demonstration by affidavit, no testimony, no other evidence suggesting that there's a substantial risk of harm that overcomes the Troxel presumption, which is that the parent is acting in the children's best interest. Now, couple that with the fact that they have, by their own admission, indicated the children were thriving and that the parent, in this case, my client, was doing everything right, which is consistent with Troxel, which is the parent is presumed to be making the correct decisions regarding their children. I also want to point out that the Mack case that's being used here to support a claim that you automatically get a hearing because you file a grandparent petition, that case is clearly distinguished from this one. In that case, as my recollection presents, involved claims that the parent had a substance abuse issue and that CPS was involved, which, as this court knows, handling neglect cases, usually involves a substantial risk of harm claim, particularly if you're removing a child. That is not the case here. It's the exact opposite. They laud him for his parenting, and part of being a parent is to make decisions that are in the children's best interest. Does this mean that Pete would never allow contact with the grandparents? No, but he is making decisions at this juncture which is best for his children and as they transition from this period of grief. A right to a hearing under the Mack case does not circumvent a C10 motion. That is their claim. They're basically saying that we don't have to cite any substantial risk of harm or have any evidence to support that. And even when we say the exact opposite, that the children are thriving and he's doing what he's supposed to do under Troxel, we still get a hearing. What would be the point? Discovery in this case is not going to create a claim. And I found it interesting that the referee in this case picked up on the fact that what they were arguing was essentially to invert the burden of proof, which was to place it on our client to somehow demonstrate that they had a threshold. That's not the standard. Also, if you look at the Mack case, there were issues with the fact that they did not provide affidavits. The court allowed them to subsequently supplement their pleadings with affidavits. But there were clear claims that would rise to the level of fact issues for a substantial risk of harm hence the requirement to have a hearing. Here, there's not even a question of fact as to whether or not there's a substantial risk of harm. They're basically saying the children have the right to the love of their grandparents, so therefore we should have a hearing. There's no proof that the children have been harmed. There's no proof that the children are at risk, and there's no proof that my client has exercised his rights as a parent contrary to their best interests. That is the problem that differentiates this case from the Mack case. If you follow the Mack logic, you could never file a motion for summary disposition because you automatically get a hearing. And then the court would determine whether or not there's threshold. Here, there's not even a question of fact as to whether there's threshold. They admit he is doing everything right and that the children are thriving. You simply cannot ignore that. This is apples to oranges if you're comparing the Mack case to this case. This is not, by any stretch of the imagination, consistent factually. So, in my opinion, and clearly the referee's opinion, I think that their admissions confirm that there is no threshold. And I think the referee's ruling should be upheld.
Thank you.
Your Honor,
As
if
I
I
said
may,
briefly,
very briefly, yes, very briefly, Your Honor. I do want to point out here that the timeline in this is very important. I think that it's important to look, and this is where we come into a genuine dispute of fact here. The timeline is important because there was contact happening, and then Mr. Bowitt got his current girlfriend, and then contact continued. Then there were conditions placed on that parenting time, on the grandparenting time after this relationship happened. And then that's when it stopped. So I do not think that to say then my clients filed this. So to say that their communication to Mr. Bowitt in and of itself presents that there is no threshold here and that there's no harm to these children, I think is disingenuous. Furthermore, I have a difficult time understanding how anybody can look at this and look at these children losing their mom, have consistent contact with their grandparents, even with the new girlfriend in place, and then that getting taken away so abruptly. When you have two things being lost, it's difficult to say that that's not going to cause some sort of emotional or psychological damage. And so, Your Honor, we would request at the very least a hearing to be able to present that information, Your Honor.
all right, thank you. We are talking about the constitutional right to parent here. And the threshold first that has to be met is whether or not we're dealing with a fit parent. In order to overcome that presumption, some evidence, affidavit, or something has to provide the court with an open door to begin challenging the parent's right to make decisions on behalf, a fit parent's right to make decisions on behalf of their children. And then you get to whether or not there's a substantial risk of harm if visitation is denied. The court agrees with the referee's assessment here. This is an attempt to flip the presumption on its head. And the court is going to deny the objection to the recommended order and leave that order in place. To do otherwise in the facts that have been presented to the court would open the door for every grandparent everywhere to require that parents go through not only a hearing but an evidentiary hearing without at least providing a prima facie case to open that door. All right, we are adjourned. Thank you.
The order.
And we are here on a motion to reduce the statutory waiting period in this matter. I have read that motion. Mr. Terneri, anything else you'd like to say?
Yeah, just briefly to flesh it out for Your Honor this morning. As you know, we need to demonstrate an unusual hardship or compelling necessity. I point out that the parties have negotiated and mediated their own property settlement or complete joint settlement. They started that with with Mike Tabiran and concluded on April 18th. So that's been a while now, Your Honor. And in my opinion, they've behaved in really exemplary manner towards their children. There have been some really difficult property, I'll say, not disputes, but they managed property together and had business entanglements together that they have disentangled largely on their own. And that's caused a lot of stress for the family, which has been, I think, successfully kept away from the children. But that stress persists. And I think at this point, they're as much trapped in the divorce process itself as in a marriage that they don't want. They are unable, as you know, to legally divide the property until Your Honor were to sign a judgment of divorce. And that's what we're asking you to expedite here today. Did you have a
Right.
question?
No, I didn't. As I said, I did read the motion, so I'm
Yeah.
aware of all the,
Okay.
of the party situation. I will find that there's compelling necessity to grant the
Thank you.
motion. I will grant the motion. And, do you wish to preserve proofs, or has
I
it
would-
been 60 days?
It has been 60 days, Your Honor.
Okay. All right. Well,
Um,
then let's take proofs.
Absolutely. Thank you, Your Honor.
All right. Ms. Carey, would you raise your right hand? Would you state your name and spell it for the record?
Emily Carrier, EMILY CARRIERE.
And do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Tierney.
Thank you. Good morning, Emily.
Good morning.
So at the time of the filing of at the time that we finally got this stamped, had you resided in Kent County for the previous 10 days?
Yes,
Do you still live in Kent County?
I do.
And at the time of the filing of the judgment of divorce or the petition for divorce, had you lived in Michigan for 180 days?
Yes,
Do you still live in Michigan?
yes.
Sorry to have to ask you this. I think we went over this. Any chance that you're pregnant today?
No,
And then the identities of your children are protected, but I just want to make sure we have 3 minor children.
Mhm.
They're all still minors at this time.
Yes.
Thank you. Has there been any sort of domestic violence at any point during the relationship? Do you remember signing a domestic violence screening form?
I do.
Wait, thank you.
Yep,
That was true when you signed it.
correct.
You and your husband, or you and Aaron, negotiated a settlement for Mr. Chabiran. Do you remember that?
Yes,
And then we worked together to put that into a consent JOD. Do you remember that?
yes,
Have you had a chance to review all the terms in the consent JOD?
I have.
Do you agree with all those terms?
I do.
Have you had a chance to look at the property terms specifically?
Yes,
And do you remember we talked about those?
yes.
Any objections, any changes that need to be made?
No,
We spoke about spousal support. Do you remember that?
correct. Yes,
You had a chance to review that term.
yes.
Any problems there?
Nope.
I believe that's it, Your Honor, unless I missed something.
You did, but I'll ask it. Has there been a
Thank you.
breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes, correct.
Thank you. The court finds that the proofs are sufficient, and the judgment may enter upon proper presentation to the court. I would ask that that proposed judgment be emailed to my clerk, Ms. Van Noller. I can sign it electronically and get it right back to you.
That would be great. I will do that
All right.
right
Best
away.
wishes to both of you. We're
Thank you.
adjourned. We are here on the plaintiff's motion to compel answers to discovery, as well as the DRV FIF and attorney fees. Ms. Tompkins.
Thank you. Your Honor, I don't want to take up much of the times court because everything stated in my motion is true and remains true. I do not have full answers to the verified financial statement. I don't have answers to my discovery. This is not Ms. Toucher. She has been communicative, and I'm not trying to disparage in any way opposing counsel. This is squarely on Mr. Spacuzza. This is very straightforward, simple, and required documents. This morning, Ms. Toucher made sure she sent over 2 additional things that she had received from Mr. Spacuzza, which are wildly insufficient screenshots from a phone that just say a number, and one of them doesn't even list an account. I'm asking that full answers be provided and compelled by the court to be fully answered within 5 days so that I can seek contempt against him if he fails to follow the court order. I'd ask for $1,500 in attorney fees because I've had to come after and after and after this. I'd also add that I just noted that the discovery deadline is November 25, and given Mr. Spacuzza's delay in this matter, I'd ask that the court consider extending that for me just in case I have to follow up after I get answers. I think that 1,500 is appropriate. We also went to mediation and we couldn't get through very much because we absolutely need his information. Thank you, Your Honor.
Thank you. Ms. Toucher, I did not see that you filed a written response.
That is correct, Your Honor. Mr. Spicozza and I have been trying to work to get over some of the VFIF and discovery answers for him. It has been a little bit challenging for my client to provide some of this information. We did attempt to remedy everything at mediation in order to not have to come here today. However, I still have incomplete statements from my client. We've had a couple different conversations of why this is important, why they need this information, so we can move forward in this process and get the parties set up successfully in their new life, the next chapter. Mr. Spicozza did send over some monthly statements. I know his pension has been quite difficult to get a hold of. We sent over our first set of answers to interrogatories on 10/13, and then a second set of an amended one on 10/15. Mediation was 10/20. We're still working on getting documents. As soon as I get my information from my client, I'm always sending it to Ms. Tompkins. So I understand that there is an issue. However, we do have discovery open. We are working on getting everything over to Ms. Tompkins, so there are no further issues in this matter.
All right, thank you. I think it's pretty straightforward what the requirements are, what the law requires, certainly what this court needs and the parties need to resolve this case. And I will grant the motion to compel. Mr. Spicuzza is to provide the completed DRV FIF and the answers to the plaintiff's interrogatories and request to produce within, I'll indicate 7 days. I will also grant the attorney fees that were requested for the preparation of the motion that was required in this matter. However, I will reserve or not reserve, but suspend the enforcement of those attorney fees or payment, provided that this information is provided within 7 days. If not, then Ms. Tompkins is to submit a bill of costs for Ms. Toucher to review and for the court to review. And is there anything further?
No, thank you, Your Honor.
All right, thank you. We're adjourned. Oh,
Just one thing quickly, Your Honor.
sure.
Would we like to extend discovery just in
Oh,
case
yes, I will extend discovery to December 30th.
Dad lays out months of stalled plans, unread texts, and maybe later excuses that kept him from seeing his own kids. The courtroom mood shifts as his calm tone turns into frustration fueled by receipts. Everything flips when the topic switches to money. Missing funds, child support numbers, and hidden income come crashing in. Both sides start keeping score, and now the judge has to figure out who's playing fair. Mom fires back hard, accusing Dad of choosing his girlfriend over his daughters and treating parenting like a part-time job. She argues the kids don't want to play house at Dad's new place, and the tension hits a new level. The judge finally steps in, shuts down the back and forth, and orders Phase 2 visitation immediately. No more delays, no more excuses. She makes it clear this family has been stuck long enough, and the new reality starts today. Child support is set, custody remains joint, and the judge warns both parents that the court will not babysit their drama. That wraps it up. Like the video, subscribe for more real courtroom moments, and we'll see you in the next one.